I'm attorney Gloria Allred. I represent one of the two alleged victims in this pending criminal case against Harvey Weinstein. Her name is Mimi, and she's very courageous. In reference to what Mr. Brafman, who represents Mr. Weinstein, stated about the Me Too movement, I would take issue with that. This indictment was based on evidence and testimony before the grand jury. It was not based on the Me Too movement. So let's be clear about that. The motion filed by Mr. Weinstein's attorneys to dismiss this case was based on, in my opinion, in part, unjustified speculation, not supported by any evidence, or any evidence that was stated, I think was out of context and will be explained at the trial.
Are you satisfied with the investigation?
I'm satisfied that this case should move forward to trial. Mr. Weinstein should have his day in court, but so should the two women who are alleged to be the victims.
Are you worried that some procedural issues may lead to
You know, it appears to me that Mr. Weinstein's public relations machine is working overtime to attempt to potentially impact the jury pool that ultimately will be chosen, to suggest that somehow there's something wrong with this case, when obviously the grand jury, after listening to the testimony, felt that it should go forward. So I'm not concerned about that. I think that headlines suggesting that the case is crumbling are incorrect. In my opinion, it's strong and it's moving forward. It's hard to hear you, but I heard. Her question was, as in the Cosby case, might there be an opportunity for other alleged victims to testify? As a matter of fact, in the motion made by Mr. Brafman, he refers to what he calls the Cosby motion. I represented 33 accusers in the Bill Cosby criminal case. One was permitted to testify as what they call in Pennsylvania a prior bad act witness in the first criminal case, and 3 out of the 5 prior bad act witnesses were permitted to testify in the second criminal trial leading to Mr. Cosby's conviction. I represented 3 out of the 5 prior bad act witnesses who did testify. In New York, it's called a Molyneux motion. It will not surprise me if the prosecution makes that motion at some point to allow other accusers who can show same or similar conduct by Mr. Weinstein to testify. My educated guess is that that's one of the major concerns of the defense, because they put it in today's motion, which of course was denied. The motion to dismiss this indictment was denied. And, you know, I think that it is relevant and probative for other accusers, if they fit the guidelines of the Molyneux motion, to be permitted to testify. As a matter of fact, I think it's essential. I said that all along in the Cosby case. And Mr. Cosby, of course, is where he belongs. In that case, of course, the defense also wanted no other accusers to be permitted to testify. In that case, they also attacked other accusers and me and the district attorney and the court and so forth. But again, none of us are ever distracted from the fact that there's only one person on trial here. It's not the district attorney, it's not the police, it's Harvey Weinstein. So this case is moving forward, and I hope that as many accusers as possible will testify that fit the guidelines. That's all. I will say that also there, in my opinion, is still time for other accusers to come forward to law enforcement. If they want to speak to me in confidence prior to that, I'm happy to speak with them. I believe that anyone who might have relevant evidence should do their duty and speak to an attorney and assess the benefits and risks, and then speak to law enforcement. I think that's very important. Last point I want to make is the attacks on my client in reference to any communication she may have had with Mr. Weinstein after the alleged assault on her. That in the motion that Mr. Brockman filed, he appears to suggest that somehow, if there are any communications by any alleged victim after any alleged crime was committed, that that undermines their testimony that an assault somehow couldn't have taken place. I totally disagree with that. As a matter of fact, my best evidence for that statement that I just made is, again, in the Bill Cosby case, where there were numerous calls and communications by Andrea Constant, the named victim in that criminal case, with Mr. Cosby after the drugging and sexually assaulting of Ms. Constant. That came into evidence, numerous cell phone calls, and nevertheless, the jury convicted. So the theory of the defense that somehow there could not have been any kind of sexual assault, non-consensual sexual activity, if there were communications with any victim after the assault, is belied and completely contradicted by the evidence. And I think once you understand the context of the communications, which I think even if you read them are completely harmless, you will understand why it does not mean that there could not have been any criminal activity. Any other questions? I'll see you on March 7th. Thank you.